Now, according to the running order, Ms Munro is next up.
Good afternoon, sir. Alison Munro. I'm instructed by Bernberg Pierce and also Dighton Pierce Glynn. And I should say at the outset, sir, that the submissions that were filed on behalf of Bernberg Pierce are adopted and supported by Dighton Pierce Glynn. So the matters that I propose to deal with very much dovetail and overlap on the very comprehensive submissions that have already been made this morning by the advocates representing a number of core participants who are the next of kin of deceased, survivors and residents. And it cuts across, or they cut across rather, those fundamental, I say, principles and legal submissions that have been made in relation to Article 2, to the question of appointing a panel, and the structure of the inquiry, and indeed disclosure. So in addressing you, I hope to deal, concisely and comprehensively, but concisely, with 4 points. Article 14, the public sector equality duty, the question of diversity and inclusion, and finally the issue of venue.
Yes, right, thank you.
So I hope what I say is constructive, and that certainly is the intention and the manner in which we make these submissions to you, as a means of opening the dialogue, again, borrowing from what has been said already this morning, opening the channels of dialogue, and hopefully having positive, constructive suggestions of moving forward, but also highlighting and flagging up those issues which we say are particularly important and indeed central to the inquiry. So I would also say that the matters that I am going to touch upon, I hope, are not regarded as soft or tangential. We say these are central, and they are founded in law and very established legal principles. So in respect to the Grenfell fire, we, and when I say we, I mean members of the public, we are all living in an age of rolling news where we see events unfold in real time. There is, because we're so exposed to rolling news and events in real time, there is perhaps a tendency for people to become desensitised or inured to what they are seeing. That didn't happen with the Grenfell fire, and that perhaps is illustrative of the nature, the extent and the gravity of what was unfolding before people's eyes. This wasn't just a local tragedy, this wasn't just a national tragedy. Perhaps first and foremost, this represents a number of personal tragedies for the individuals who are here today, those who lost their loved ones, those who survived, those in the immediate vicinity of the area. And grief isn't time limited. We've spoken about delay today, but in fact, anyone who has experienced grief will know that 6 months is actually a relatively short amount of time. People deal with grief in different ways, and the timescales for people are very different. But that has an impact upon how people are engaging and how ready they feel to engage, and what can be done by the process itself to enhance that engagement. The Grenfell fire didn't happen in a vacuum, and so we have to be alive to the realities of the situation, the socio-economic and political realities of what we're dealing with, and looking at what we're dealing with. As I said, local and personal tragedies that have national and worldwide ramifications. Those who are affected come from a diverse, and it's a word I'll be using quite a lot, a diverse social group, a diverse group culturally, racially, ethnically, by religion, by occupation, by financial background, although predominantly it's a working class community. There's a large proportion of those within the community from immigrant backgrounds, some long-standing, some more recent. That makeup, whilst it is in some respects very broad, perhaps is a reason why that community is so nonetheless cohesive, because what can be seen very, very clearly, both from the aftermath, the immediate aftermath of the fire, and in the preceding months, is that this is a very strong, very cohesive community with a clear sense of community and how they are affected. We also have to be very, very much alive to the fact that this disaster happened, as has already been said, within a pocket of one of the richest boroughs in London. London, the richest city in the UK, one of the richest cities in the world, Europe and the world. And that is a reality that cannot be ignored. We welcome, so, what has been said by the inquiry team in terms of putting those directly affected at the heart of this inquiry process. But many still strongly feel that their voices are not being heard. Indeed, it is a real sense from many of those that we represent that in the past their voices have not been heard. And perhaps if those voices had been heard in the past, we wouldn't be here today. So how can the inquiry and the process itself ensure that those voices do not go unheard this time round? As we have said in our submissions, firstly looking at Article 14, it's a prohibition on discrimination, which requires that rights under Article 2 that are engaged in relation to the inquiry must be equally available to all core participants, regardless of social status, disability, ethnic origin, or age. And I should say at this point, pausing for a moment, when looking at the community, I've mentioned a number of different factors. We need to also to be very much conversant with the fact that we are looking at a community that has a number of people with disabilities. There is a large proportion within the community of young people, young parents with very young children. We are also looking, and this very much comes into the second point about the public sector equalities duty, we are also looking at a group of individuals who are actually suffering a disability. And I say that because of the trauma that they have experienced as a direct consequence of the fire. It was something that Mr. Mansfield touched upon, and perhaps it's not something that has garnered a lot of traction at the moment, but it will, as I'm sure time progresses and as more comes to light, that clearly there are a lot of people who are still suffering trauma as a result of what they saw, what they experienced, and what their families experienced. And it would be morally repugnant and indeed unlawful for the playing field effectively not to be a level playing field, so that they all can participate and be engaged in a meaningful way. As I said, sir, the question of diversity, it's a word that is used a lot, not just in the legal context, but outside of these walls, within public bodies, within other organisations, and it elicits a number of responses. Sometimes it can elicit the response of eyes being rolled, boxes being ticked. It's important, moreover vital, that when one considers diversity, it is seen as a central and important factor. And we say it's central and important because it actually adds value to the inquiry. It adds value to the decision-making process. it add value to the actual legal process. Now, again, certainly we are not suggesting that the inquiry and the inquiry team have not been alive to these issues. There have been a number, I understand, of consultations that have been carried out prior to the inquiry's official opening. However, the attendance has not been at its optimum, and perceptions are important, and unfortunately those consultation meetings are not perceived as being particularly inclusive at this stage. But that's not a situation that we say is irrevocable. It's one that has to be faced head-on and has to be addressed, but it's one that can be rectified. It's crucial that those in the community feel invested in the process. They feel that and it undermines the confidence if they're not invested in that process. I know, sir, that it is something, as I said, that the inquiry team are alive to, but it's important that it's not simply recognised, but power is given to the words and intention. There is a real perception and a real deeply held feeling amongst many of those that we represent that their effective participation in the inquiry process has been compromised. Those at the heart of the disaster need to feel that they are being listened to, as I say, but also they need to feel that they are not simply passive bystanders to the retelling of their own history and the facts of their own history. Mr. Mansfield has already highlighted and drawn your attention to the report by Dr. Stewart. I would commend that report to the inquiry team. It is a concise but very, in my submission, trenchant piece of work. It explains in very clear terms why issues of diversity are so important in the context of a disaster. They make parallels, or rather Dr. Stewart makes parallels with other inquiries, such as the Lawrence inquiry, and how an awareness of diversity and inclusion was fundamental to enhancing public confidence and community engagement, and ultimately added value, as I say, to the inquiry and the decisions that were made and the reports that were filed. So one has an eye to that question of raising and enhancing public confidence. And that very much, as I said at the outset, so ties in with notions of the appointment of a panel and the structure and scope and breadth of the inquiry. They all feed into notions of community engagement and enhancing public confidence. As Dr. Stewart points out at paragraph 5 of her report, the Grenfell Tower inquiry would do well to garner the confidence of the local community to encourage their engagement and feelings of inclusion in the procedures in order to improve the investigation by learning the lessons on the importance of social, cultural diversity from the Stephen Lawrence inquiry. And that perhaps encapsulates, as I said, the points that she makes in that report. In terms of community engagement, as I said, so the structure and having those who represent or reflect the community as part, a real part of the structure of the process, again, will enhance that level of confidence and that feeling of engagement. So I won't repeat them because they're there in the submissions that we drafted on behalf of Bernberg Pierce. And I think they've already been alluded to this morning, a number of authorities, which deal with that question of putting the victims and next of kin at the centre of matters, but also this question of humanity, dignity and respect. And they're three small words, but they have tremendous impact. These are individuals, many of whom are sitting at the back of the room, who ask for, and it's not a big ask, they ask for dignity, humanity and respect in the way that they are treated and the way in which they are provided with engagement and an opportunity to engage in this process. Now, that involves not simply the legal and structural matters that we have dealt with, but also looking at the individuals and putting in appropriate measures to ensure their well-being, both physical, emotional and psychological. The inquiry should ensure that next of kin, survivors and residents are afforded special consideration and care to avoid being further traumatised by the process itself. And that is something so that one has seen in a number of different inquiries and inquests where individuals say that the actual legal process itself can be quite dehumanising and traumatising. So that brings me then on to the question of venue. Obviously, we are in this room. It is stuffy, perhaps to say the least. It has become more and more so as the morning and the afternoon has gone on. It is not perhaps the most ideal from the legal point of view, but put the lawyers to one side. I make my submissions on the venue primarily in respect of those that we represent. Initially, the inquiry was, of course, going to be at the Connaught Rooms, and Bernberg Pierce made representations in relation to that and why those provisions were inadequate. And those representations still hold in regards to the new venue, this venue. I note from paragraph 62 of Council's statement that it is said why the venue was chosen, and I quote, "The venue has been selected because of its central location, good transport links to the Latimer Road area, and suitable disabled provisions. It is large and well provisioned enough for the operation of the inquiry and the accommodation of a reasonable number of those wishing to attend the hearings." That may be true to an extent. Its central location, one would say central primarily to the lawyers, and one can even demarcate it even further, perhaps central to the bar, and not necessarily central to a lot of the solicitors who represent those members of those next of kin, residents and survivors. In terms of its location, in terms of the building itself, we represent, as I said, a diverse group of people, many young parents, those with young children, those with disabilities. Travelling to and from, if they want to fully engage and be physically here, has a cost, a financial cost. Central London, lunchtime provisions for food. In terms of the engagement with the legal teams, conference rooms, facilities for that. Ensuring that those who come can participate because of they may need interpreters, they may need other specific needs to that individual. Those are matters that are important. But overriding all of that, many of those that we represent say that the choice of venue, and perhaps had there been a greater level of discussion and engagement with the community, may have resulted in a different choice. They have been looking themselves at alternatives in the locality of the area. At the moment, amongst those that have been identified is a local college as an alternative venue. It would need to be kitted out effectively in terms of provisions to make it the home of the inquiry, but there is time to do that.
I think they'd also have to be able to make available enough room for long enough, wouldn't they?
So yes.
Could that be a difficulty? I don't know.
That may be a difficulty, but again, it is not insurmountable. As has already been mentioned, there are many of us here who have been involved in similar, certainly out of London in my case, long-running inquests in which the question of venue was something that had to be revisited and was overcome. there is time to do that, and certainly what we would ask at this stage is that dialogue is opened, and there are options that need to be looked at, whether they are viable. So for the reasons you've mentioned.
You mentioned the college. Is that Kensington and Chelsea College?
Yes.
Yes, thank you. Right.
So those are the kind of things that would need to be looked at. The viability in terms of long term, because clearly we are looking at well into the future in terms of how long this inquiry will run and to to But those are not insurmountable, and we have time to do that. And it's something that very much has exercised those within the community, the question of venue. And certainly they would not want it to be seen as an add-on, as I said, a tangential or a side issue compared to the very, very important legal matters that you've heard about this morning and will hear about further in due course. Because it affects, again, going back to the question of participation and engagement and confidence, if one cannot physically get to the inquiry, or once one is there, you can't physically participate because of a lack of services or a lack of room or just financially, the prospect of bringing a small child, having to find food for that child. These are practical matters, which I know others will address you on, but they feed into the whole question of venue. So we would certainly say the time is now and the opportunity is here for us to look at this afresh. There is one caveat in relation to venue that I know that some of the residents, survivors, next of kin are concerned about another council building being used. But I say that as a caveat, but the overall position is that the venue, they say, should be one locally to allow better access for individual members of the public as well as those we represent. So I think, in fact, I've covered those four matters, keeping in the trend of this morning within time.
Yes, you've done very well. Thank you very much. Yes. Well, thank you very much for your submissions. Now, Mr. Steen, I think you are due to speak next.
So, working with my junior, Mark Henderson, and the solicitors team from Howe & Co, we take a firmly pro-family, pro-survivor and pro-community core participant stance. We will remind and emphasise this inquiry, where required, that the reason why the core participants we represent have been granted that status within the Inquiries Act 2005 is that the 65 that we represent are before this inquiry because they have lost loved ones. They have been injured. They have been poisoned by cyanide. They have been taken to hell itself. This means, and the driver therefore for our submissions, is that we ask this inquiry the simple question of when will it start? When will the truth come out? When can we start seeing the defences and potential excuses which will be raised by companies and institutions at fault? For the purposes of these submissions, we will refer to our written submissions and follow the same order. May I deal first of all, therefore, with statement taking from core participants and the giving of evidence before this inquiry set out at pages 2 to 4. We recognise that a real priority for this inquiry relates to the statement taking from core participants, and indeed a question that you need an answer to, which is when can that be completed? It is obvious to us that this is a major part of the process of getting this inquiry underway. Answering, therefore, the question of when the inquiry will start. And we know also that the inquiry needs to have these statements so that decisions can be made as to the measures that are going to be required in order for evidence to be given. These answers to those questions are of real importance to the inquiry, and they affect the basic planning of the inquiry itself, the length of evidence, the practical steps and technical needs that will be required from the giving of and the receipt of this evidence. Equally, we understand the questions asked in the draft guidance provided by counsel to the inquiry, though lengthy, are at least in part designed to provide answers for the experts who are considering the various parts of this disaster. Those experts need answers as far as possible, moment by moment, as to the spread of the fire, the so-called fire safety advice, and the way that the emergency services acted. Howe & Co., my instructing solicitors, have some very real and recent experience in the statement taking from traumatised individuals. And we know that sometimes it can be a relatively straightforward task. But other times, sir, the grief and terror intrude so much that it can become a longer process. As has just been mentioned, people react different ways, and there is no right or wrong way. Equally, we have the very real practical problems of dealing with so many people still trying to bring a semblance of order to their lives. The answer that we have, and I hope helpful, is that we are starting the process of statement taking immediately, and we will not wait until all disclosure is complete. That has already been set out in correspondence from Mr. Howe on the 8th of December. Of course, we need disclosure. We need disclosure of the main parts, if not all, of the relevant evidence that can be provided from statements made and interviews that have been provided to the police. But that can be brought into those statements when it is made available. But it still does represent a need for that disclosure process to be completed as soon as possible, and we hope in January. We intend to take the statements as a whole and not leave out the part of the accounts to comply with any phasing of the inquiry analysis. The reason for this that we have considered is that the people we represent want to be heard, and they want their accounts to be given, and given in a way that deals not only with what happened in the lead up to the fire itself, but also the failures we suggest by the local authority and the state thereafter. The best way for statements such as this to be provided, we have found, is to allow the individual to provide their own narrative account of the incident, and then follow that with answers to the more detailed questions being asked through the inquiry guidance document. We would be assisted if counsel to the inquiry identify for the solicitors' teams carrying out this task the essential questions that are required by the experts. Now, that is because the current guidance on asking questions is some 200 questions and sub-questions, and the identification of those that are required by the experts sooner rather than later would be of real assistance. Further, it may be of assistance for the inquiry, and Chair, for you to consider that there is a need to have information from core participants who are providing statements as to how they would ask their evidence can be given before the inquiry, because that is a practical need that this inquiry needs to have answered. The very many courts that exist are very used to the different ways that evidence can be provided, from the witness box and in full view, from behind screens, over a video link with views limited to the chair and representatives, pre-recorded interviews, and sometimes, of course, anonymously. The question of survivor core participants, residents from the area or from those people most affected. Questions of those individuals may be requested to be asked by core participant legal teams. We ask that you deal with such requests with care. We suggest that such questions be indicated well in advance and over a longer period than may be required by institutional or corporate core participants. In summary, therefore, we propose the following. Statement taking to start immediately. Disclosure, as already discussed, being vital to complete this process and must be targeted to be complete as early as possible in January. We understand, of course, this may be phased, but the inquiry should not halt its disclosure process until complete, because we can read as we go through the disclosure in phases. And we'd also suggest that there is a date set by which at least an indication of which method or process for giving evidence will be likely to be required. And you'll forgive me for adding perhaps the completely obvious. This is only an indication and should not be regarded as the final answer, because people's views may change. May I then move on to the core participant support points that have been raised already and we've set out in detail at page 5. For those giving evidence, there is a need to ensure that support is available. That can come in many forms. Trained counsellors, the presence of a friend or a relative, and of course, basic interpretation when required. But there is also a need for more general but equally vital support for those core participants who need practical assistance with childcare, transport and costs, whether they are giving evidence or not on any particular day. Travel, attendance and subsistence allowance and/or loss of earnings must be considered for attending hearings and meetings in relation to the inquiry, including meetings with solicitors. The provision of childcare at inquiry events, at inquiry days, the provision for the cost of that childcare to support meetings in relation to the inquiry, including, again, meetings with solicitors, support for regular, small, incidental expenses incurred by core participants, for example, the cost of printing, of documents that have been circulated, mobile phone credit to support contact with solicitors and, where necessary, the inquiry, access to computers and iPads or similar. Here, it would be wrong for me not to pause and thank the work of Rugby Portello, who have, I think, orchestrated and have been provided by companies such as Apple the handing out of many laptops and iPads and the like, not only to the bereaved, but to many others who have been affected. There is still, though, the need, as I was myself reminded this morning, to recognise that many core participants have lost all of their belongings, are still living in emergency or temporary accommodation, and have great difficulty in accessing the inquiry's website and receiving communication from the inquiry and their representatives. This is a real stumbling block, and we suggest it may well have been a shock to the inquiry team to learn how many core participants still live in single rooms in hotels, even to this date, and many will do so over the Christmas break. In terms of further practical arrangements, it has been set out in some written submissions that a 4-day sitting week of the public aspect of the inquiry might well assist in managing family responsibilities. It also is a practical way forward sometimes when dealing with large-scale inquiries or inquests to sit on 4 days, because the 5th day is either a useful day for the inquiry chair and team, but also, where necessary, if there is a need to deal with detailed legal submissions.
Well, I think there's pretty well unanimity on that question.
The inquiry site and its location has already been mentioned. We echo all of those submissions. It must be closer and must be closest to those people that have lost so much. The inquiry site must also allow for all faiths so that religious observance can be maintained, as well as providing a quiet space for those who simply need to get away and clear their heads. I turn now to the questioning of witnesses on behalf of core participants. We hope we can take this briefly, and we hope, helpfully, the trap that an inquiry can fall into is to overly limit the questioning of witnesses on behalf of core participants. This is an error. It engenders a feeling of exclusion and non-participation. Plus, frankly, it also leads to requests to hear submissions on these points, which actually tends to hold up the process. The preferred way is to simply limit further questions to new areas or new directions, and not to allow repetition from core participant representatives. Expert evidence and timetabling, page 7 of our submissions.
Yes.
As recently as the 30th of November, the inquiry requested that core participants make any submissions about inquiry expert witnesses no later than 4 p.m. on the 4th of December 2017. We submit that this type of timetabling of submissions and responses is wrong and devalued the participation within this inquiry of core participants. We submit this must never happen again. Doing this and accepting such timetabling, if we were to, would mean that the only dialogue that you will have will be only with lawyers, and it will become a chat between us and the inquiry, and it will lose the participation of core participants.
I think, to be fair to the inquiry team, they were intending to ask for immediate responses in time for this hearing. I don't think anybody contemplated that responses received later would be ignored. Make that clear, that's all.
It perhaps, may I temporise then for a moment, it perhaps should have been dealt with a little more care, because the correspondence did appear to give it as a final line. But may I assist? Mr. Millett, Queen's Counsel, this morning accepted in his address that in fact later submissions would be welcome, and so we are grateful for that. But there's a further factor that is troubling, not only the short potential timeline to comment on inquiry experts. We're not at the moment informed of the basis, although it's been raised already, of the concerns raised by the Fire Brigade Union. Now, many core participants may wish to consider that. Submissions from core participants about matters of general concern, such as expert evidence, should be circulated to other core participants, so that there can in fact be an understanding and a dialogue amongst core participants as to requests that are being made. The second point we make about experts, and we note this morning this may have been accepted by Mr. Millett, is that the bereaved, residents and survivor core participants should be allowed to engage their own experts, engage their own advisors, and be allowed the space, the time and opportunity to meet with them and go to the inquiry with expert reports that they've had time to consider and understand. It's obvious, as we've seen already foreshadowed in submissions made by corporate core participants, that they have the resources and the ability to have recourse to their own expert assistance. So we suggest that it is made clear by the inquiry that this is an opportunity that will be given to core participants from the block and from surrounding areas. Of course, we don't make this submission without thinking about the consequences. This is not going to be, we suggest, an opportunity for every single legal team, every single firm of solicitors to engage their own experts. It is likely and probable that the inquiry would expect us to cooperate and act together in relation to joint instructions. That is obvious, but equally it is obvious that when doing so, that is in fact a time-consuming exercise. And the ability of 200 plus core participants, when they want to have access to experts and consider matters with them, is something that will take planning. And so, again, going back to questions that have already been foreshadowed about disclosure, the sooner we have expert reports that can be considered, the better. May I then move on, please, to deal with disclosure rather more pointedly. This has already been dealt with largely by Mr. Weatherby. This is at page 9 of our written submissions.
Yes.
We strongly support the proposal that public and corporate core participants be required to file a statement of their position, including any failing that they accept on their own part, and that they must be guided by a duty of candour in what they say. Now, to an extent, the duty of candour is a legal phrase that has been used in relation to judicial reviews, but the guidance on this applies equally to inquiries and inquests. The duty of candour is relevant in a second respect to the adequacy of the disclosure exercise. For public authority core participants, we urge their adherence to the guidance on discharging the duty of candour and disclosure, that has been set out at 2010 by the Treasury Solicitor. And that was published to address concerns about the inadequate appreciation of candour and disclosure duties by government departments when dealing with judicial reviews. This document, published in 2010, states that the guidance may also be relevant, as we've said already, to inquests and inquiries. The failure of public authorities to appreciate the extent of their duties to make reasonable searches and how to go about them is a long-running problem. If I may just very briefly quote from that document. A public authority's objective must not be to win the litigation at all costs, but to assist the court, in this case an inquiry, in reaching the correct result, and thereby to improve standards in public administration. We ask that not be forgotten. But lawyers for institutional and commercial court participants must be reminded of their own fundamental duty to ensure that their clients preserve documents and make adequate disclosure searches. We have emphasised the broad approach to relevancy of documents that is required also as part of the restoration of public confidence, and that in fact is a wider test than standard disclosure under the CPR, the Civil Procedural Rules. Public confidence will also be assisted by the victim and survivor court participants having a proper opportunity to engage in the disclosure process. We have observed in our written submissions at paragraph 29 that we have yet to see the original disclosure requests, despite the inquiry having confirmed that sight of these might not be problematic. We understand this is a matter of some debate at the moment. We will appreciate that the inquiry does not wish to engage in matters which procedurally will lengthen the process. But it is possible, no doubt because the inquiry itself is keeping a record in some form of schedule or chart form, to potentially have access to those inquiries and questions that have been raised so far, so that gaps that we identify can be identified and filled. So we look forward to a discussion with the counsel to inquiry and solicitors to the inquiry, so that we can consider the best way to approach that particular problem. But as matters stand, the court participants we represent have been unable to review the scope of disclosure sought from the public authority and corporate court participants. And therefore, as things stand, we have been unable to make any effective submissions on it. And that, we suggest, is not right. We also agree that it is vital that all court participants are required to make a proper disclosure statement, explaining how they have secured the preservation of documents, how they have conducted their searches, and how they have satisfied themselves that they have complied in full with their duties. Now, this is not just a formality. It serves a vital role in holding them to account and in enabling fair and meaningful engagement from the victim and survivor court participants in the disclosure process. And so Mr. Millett has already said this, and we agree with him, that in practical terms there should be a meeting between representatives to deal with those sorts of issues. Practical matters in relation to disclosure include the question of what system is going to be used. It may well be that this inquiry will use the relativity system that is of assistance in relation to an inquiry that we're already part of, working with Howe & Co. That is the child sexual abuse inquiry. We have learnt through using that system that there are some issues that need to be grasped. Training in its use is welcome. Care needs to be had in terms of loading non-searchable documents. And there is a definite need for indexing to be completed with care, and so that it can be employed properly. The inquiry panel and diversity of membership, page 11 of our submissions. This has been addressed already. We support the principle that the inquiry should in fact incorporate individuals with a background that is more representative of the community. But there are additional ways, not instead, but additional ways to involve victims and survivors in this inquiry. examples of which are currently being used in the child sexual abuse inquiry. This includes a rolling programme of open seminars facilitated and attended by counsel and solicitors to the inquiry. Now, this has been successful as part of that inquiry process. It allows open and robust discussion and debate to be had between core participants and the inquiry. It goes further than simply acting as a discussion group, because it allows the seminars allow themselves, and people that attend it, to be used as a test bed for suggestions and indeed potential recommendations. Let me make this simple point that probably is now obvious to you, sir. The community and the tenants are the experts in being the service users. They are also the people who lost their lives when those services went wrong. They deserve the dignity of being able to discuss and appropriately inform this inquiry. Now, you've already mentioned, when discussing matters with Mr. Mansfield, that the inquiry could consider the employment of a victim and survivor consultative panel. This is a method of engaging people with an inquiry that is used by the Child Sexual Abuse Inquiry. It works. It is a layered approach to engaging with the community and with core participants, so that you don't just have a survivor and consultative, victim and survivor consultative panel, you have seminars as well. The consultative panel, the way it works normally, is allowed a day or week, or a day every 2 weeks or something similar, to consider the practical steps that are currently being taken by the inquiry and what further suggestions would help you. The seminars allow for people to engage with the ongoing work of the inquiry and feed their ideas, not their decisions, again to you. That then brings me to decision-making and recommendations. This has been addressed variously in terms of the phasing suggestion that is being made by the inquiry. The choice of what is or is not included within any phased or module aspect of this inquiry is a matter that we will address further in writing. But as an example, the stay put advice is a matter that we respectfully submit should very much be part of phase 1, if that is what you do, sir. But all of your work, all of our work, will be lost in a library, slowly gathering dust, if it is not accompanied by attention given to implementation and oversight of change. This means report yes, where required. Come to interim decisions, yes, where required. Recognise when change must occur, yes, where required. But do not let this go quietly into the good night. What you must do, sir, is make sure that change is carried through where required. The danger being, essentially, that the inquiry closes without there being oversight. And so, please, sir, when you are getting to the stage of considering any recommendation, one of the advantages of doing so within the life of the inquiry is that you also oversee change and implementation. And that is a matter that can be considered during the ongoing work of the inquiry. So, no doubt, by now, you will be more acutely aware than anyone else that the reason why you have been appointed to chair this inquiry is so that you can examine potentially the failures in the work of others. This may be the most difficult work that you and Council of Inquiry have ever undertaken. Much of what will be before you will be unfamiliar, as you will be having to consider the many areas that are within the remit of this inquiry and not be afraid to turn over the rocks and see what horrors lurk underneath. I return to my main theme, which is do not make the mistake of discounting the work and contribution that core participants can make to this inquiry. It is a mistake to say that they are simply witnesses. They are not. The core participants we represent will not just bear witness to the circumstances leading up to and surrounding the fire at Grenfell Tower on the 14th of June 2017, those court participants also have opinions about how matters can be handled in the future, and their ability to be heard on safety matters, about relationship with the local authority, and of course about the way that fire safety can be delivered in the future will be vital to this inquiry's success. The court participants we represent have a voice and have opinions that are valuable to you. Listen to them and please don't reject them. So if you do this, and your inquiry team are seen to be getting to the truth with bravery and conviction, you will have support. But, already spoken of by others, the gaining of trust from survivors of a tragedy of this magnitude, where people's lives have been broken and ruined by the very state that appointed you, is not easy, and it will take time. So those are our submissions. Can I assist me, Colonel?
Mr. Steen, thank you very much indeed. They're very powerful and helpful submissions. Thank you very much. Now, Mr. Thomas, I think you're to speak next.
I am.
Very good.
Good afternoon,
Yes.
sir. Leslie Thomas, and I appear with Junior Counsel Thalia Mirage. We're currently instructed to represent 17 people, 17 court participants, including bereaved families, former residents of the tower, residents of the walkway, and also a survivor who was neither a resident of the tower or the walkway, but was visiting a friend on the night of the fire. I'm instructed by 3 firms of solicitors: Hudgels, Saunders Solicitors and James Solicitors. Last week we indicated to you, sir, that we were going to divide up some of the topics. The topic that I would like to address you on, or topics I would like to address you on, are experts, which has been touched upon already.
Yes.
And also, I want to come back to the theme of diversity.
Yes, very well.
Sir, it goes without saying that we mustn't lose sight of the fact that the victims, the victim call participants, should be at the heart of this process. Mm-hmm. And in a way, that very much informs the approach that we, when I say we, those of us who represent victim call participants, approach the question of expert evidence. And I say that for the following reasons. Fundamental to the process of the inquiry is the equality of arms. We want to be in a position whereby at the end of this inquiry, we can say to our clients, well, you know, regardless of the result, regardless of the decision, you had a fair crack of the whip. Just pause for one moment, and I say that respectfully, and consider that. We already know that some of the corporate court participants have already started the process of engaging their own experts. How do we know that? Well, they've said so. They've said so in their submissions to you. The one thing that you know, sir, that those who we represent, our pockets do not run deep. Therefore, we are very much dependent on you and your team to ensure that we are given a fair crack of the whip when it comes to the question of experts. Because, yes, it's right that a lot of your inquiry will be taken up with the personal accounts, the personal histories, the stories as to what happened on that night. But a lot of that will be informed by the advice given by experts. So, let me turn to experts. It's important that we have meaningful participation in the process of experts. And for there to be meaningful participation, it's right and it's important that we have disclosure, and we have disclosure early. So you can't put the cart before the horse. To be able to instruct experts properly, we need the documents. Why do we need the documents? Because we want to be able to ask the right questions of the expert. Now, that doesn't mean that we need all the documents, but we certainly need more documents than we have at the moment, which is none. Yeah? So that's really important. And it cannot be lost on you, or indeed your team, that if your aim is to be fair, ensure a full process, a meaningful engagement, there are certain steps that need to be taken before other steps. And I'm not going to address you on disclosure because that was done already this morning, and you know what the arguments are. But it is important that disclosure cannot be looked at in isolation. It runs hand in hand with the instructions of experts. I'm glad to see, and a lot of my steam was taken away when your council this morning gave an indication that many of the concerns that we had are going to be addressed, and we thank you for that. I'm glad to see that the expert CVs will be provided, that we will have more time to have input in terms of the letters of instructions, so that there can be more meaningful engagement in that process. Can I touch, sir, upon some additional and further experts that we would invite you to consider? So I've already told you, on behalf of the victim core participants, of our need to play a full role in this process. Let me add a little bit more meat to the bones when it comes to experts, and you'll see why. In terms of asking questions, and indeed in terms of knowing whether or not all the disclosure, or the right disclosure, or whether things may have been missed, hidden, disappeared, who knows? We needed expert input into that. We would invite you, sir, to also consider the following expertise or expert opinion on housing construction, that being separate and distinct from refurbishment and maintenance. What you tend to find, sir, is those who are engaged in large-scale projects such as housing construction don't normally deal with the maintenance afterwards. It tends to be separate. And therefore, having an expert in the construction, we would invite you to have a separate expert in terms of once the building has been constructed, how it therefore is maintained. Because you tend to find that, you know, I'm not talking about small projects, I'm talking about a large-scale project. And so I see you understand the point I'm making. In terms of the refurbishment and maintenance, we subdivide that even further. It's important to note that this is not purely about the refurbishment programme, but also can be divided into three areas. So those three areas are as follows. Firstly, the original construction. Secondly, whether there was a need for other works after the original construction. And finally, we would invite you to consider the 2012 to 2016 programme of works that was undertaken. We submit that it's very much doubted that a single expert could address all of those issues. So we would invite you to consider in this inquiry the use of an independent environmental health expert. We suggest that sort of expertise is needed in a case such as this. We'd also invite you to consider an expert in the management of the aftermath of a disaster, which may have been touched upon this morning. If it has, forgive me, I repeat it. I think it's worth underscoring the point. The final thing I'm going to say about experts before I move on to the second area, because a lot has already been said, and I don't want to be repetitious, is the importance that there is a proper timetable put into play which gives us a proper opportunity to consider documents, consider the disclosure, and make meaningful and timely submissions to you and your team. You would expect that in every other legal process. Why should this inquiry be any different?
Well, I couldn't agree more, and I'm hoping that perhaps on the next occasion we meet for directions, we can put a timetable of that sort into place with everyone's contributions.
I would hope so too. A lot will very much depend, sir, on the first stage, which is getting some disclosure so that we can put some meaning to that timetable. So can I move on to some other matters? The second topic that I wanted to touch upon was diversity.
Yes.
The one thing, sir, that must trouble you at night when you close your eyes before you lay your head down on that pillow is, what will my legacy be?
No, I can assure you, Mr. Thomas, that that never troubles me.
I'm not going to suggest it should do. But let's just look at that question. What will my legacy be at the end of this inquiry? And I want to look at that in the context of diversity. And so I make no apologies for what I'm about to say, because one of the things that will not be lost on you or anybody else who sits in this inquiry, you can see most of the victim core participants because they're sitting right at the back. You couldn't get a more diverse group of people. Now look at the lawyers. Look at the lawyers who represent predominantly, because the way you've divided us, look at the lawyers who represent predominantly the corporate core participants. And even to an extent, look at those of us who represent the victim core participants. Fairly homogenised group, wouldn't you agree? Apart from the odd exception here and there. What must they be thinking in terms of, are we going to get justice? Do they understand us? That is why, sir, the submissions that were made to you about the panel, the representation on the panel, this isn't just lip service. This isn't saying, I want somebody who looks like me for the sake of somebody who looks like me. No, it's much more than that. Does this inquiry pass the smell test? What is the smell test on an inquiry such as this? Well, I've already said look at the suits. I've already told you to look at the victim core participants. I've asked you to take a long, hard look at your panel, your assessors, your team, and ask yourself, does it pass the smell test? Because that relates to perception, public perception. Do they understand us? Do they speak our language? Do they know anything about social housing? How many of them have lived in a tower block or on a council estate or in social housing? That affects confidence. Confidence, or a lack of it, affects participation. And a lack of participation from the very people who matter will affect justice. And a lack of justice is injustice. That's all I have to say, sir. Thank you very much.
Well, thank you very much for your submissions. Now, my running order, which may not look like yours, suggests that Mr. Bates, who's here for Russell Cook, had asked to address me next. Is Mr. Bates here and ready? Well, then you better come and do your bit, Mr. Bates. Thank you. Yes.
Yes, sir. My name is Justin Bates. I'm standing in for Mr. Arden, QC, who can't be available today. And we're instructed by Russell Cook on behalf of 3 core participants. There are just 3 brief areas that I'd like to address you on, if I may. The first concerns your assessors, the second concerns your experts, and the third is to pick up a question about the housing file that has been raised by some people earlier this morning.
Yes.
On the question of the assessors, we accept and acknowledge that you have decided this will not be an inquiry into social housing policy. But you have decided that you will need to look at questions of social housing management. You will need to look at questions of relationships between different kinds of managers, both the council and the TMO, and you will need to look at questions of management as between the managerial bodies and the occupiers. You will also need to look at management and procurement of works programmes. We respectfully suggest that your present assessors don't give you the expertise you would require in those fields. Mr. Montgomery is a noted urban regeneration specialist, but at the risk of oversimplifying, his experience is to identify which estate and which block needs work, not how you do that. Mrs. Redfern does have local government experience, but not directly housing management experience. The inquiry website flags up her time at Wigan, but Wigan, of course, managed their housing stock through what's called an ALMO, an arm's length management organisation. And at the risk of telling you what you may already know, where one has an ALMO, the effect of that is to put an additional layer of bureaucracy between the council and the management of its stock. So identifying one's experience in relation to having worked for a council who has an ALMO is in fact to flag up the lack of experience one has in social housing management. And as we said in our written submissions, we respectfully suggest that this inquiry would benefit from someone with active experience of housing management and particularly tenant involvement in social housing management. And we've suggested that an additional assessor should be appointed, namely a tenant who has experience of the management of social housing. And we've given some suggestions as to where one might find one of those in our written materials. Secondly, on the question of experts, part of what I say now will be picked up later on tomorrow by the FBU, But respectfully, we ask you to approve at a very early stage funding to allow core participants collectively, as was indicated earlier, to identify experts to assist now. Firstly, to comment on and suggest improvements to the letter of instructions, and your counsel this morning indicated he'd welcome that kind of input. But respectfully, the lawyers in the room don't have the experience to assist with what should go into those instructions. Secondly, as Mr. Thomas just alluded to assist with monitoring of the disclosure process, so that at a very early stage, experts can indicate what, if any, classes of documents they would expect to see that have not yet been identified. And thirdly, to ensure that all relevant lines of inquiry are pursued. So you've seen the FBU's submission, for example, asking, quite correctly in our submission, why no one's been asked to comment on Part 1 of the Housing Act 2004. And Part 1 of the Housing Act 2004, as I'm sure you know, sir, is effectively now the standard against which housing should be judged, replacing the old fitness regime under the old 85 Act. That is something that the lawyers can identify, but in terms of the questions to be asked, in terms of the material to be explored, the core participants and their lawyers need access to people who actually use that material on a daily basis to feed into the relevant questions. At the risk of simplifying it enormously, the lawyers in the room, certainly the housing lawyers, can litigate about Part 1 issues, but an environmental health officer applies them on a daily basis and understands what material to be looking for. Thirdly, it was the housing file. If I may say so, that the housing file should be regarded as the Bible in the case of each tenant's occupation. It's everything that the authority or the other class of landlord holds about you, everything you've sent them, everything you've forgotten you've sent them, will be on that housing file. It will assist the solicitors and counsel assisting them in understanding the background to their clients. It will assist the individual clients in reminding them what they raised at earlier times and what points they've raised. It's not simply, or it shouldn't be, simply a repair log. It could be everything. Any letter that a counsellor once wrote on your behalf, anything you sent 5 years ago. In the case of a good file, it may even contain transcripts of phone calls that you've had with your landlord. And at the risk, again, of overplaying my hand slightly, in every housing case being heard by a district judge up and down this country today, there will have been an order for disclosure of a housing file. It's inconceivable, as a housing lawyer, that I would ever approach a case without having seen my client's file. Respectfully, if they're not to be disclosed, there should be a compelling reason for doing so, rather than an obligation on our clients to explain why information that they themselves generated should not have been made available. That was all we wanted to say, so I'm very grateful.
Well, thank you. It's very concise and I'm grateful. Thank you very much. Now, Imran Khan and partners made some submissions in writing. Is anyone here who'd like to speak on their behalf? Please come along then. Okay, take your time.
So may I offer my apologies, first of all, for my colleague Imran Khan, who was scheduled to speak today but has been wanted in Sheffield for a trial which has run over. So my apologies. Well, but I will be making
Thank you for standing in.
You're very welcome,
and,
sir.
Yes, when you're ready.
Thank you. Well, sir, I intend to make my submissions extremely brief this afternoon.
I'm sorry, I don't have a note of your name, which is probably my fault.
Yes, it's Ms. Ellis.
Thank you.
I appear from Imran Khan and Partners on behalf of 23 core participants who are both resident survivors and family members of deceased parties.
Yes, thank you very much.
The submissions that we had intended to make today, a large part of them have been adopted in the submissions made by those who precede me, and I don't intend to repeat those. So I'm instructed here, in particular by those attending today, just to underline really two key points. Yep. The first is simply to join others who have been represented earlier in the day today in pleas for members of the community to be part of a decision-making panel rather than a consultative panel. In particular, I endorse the submissions of Mr. Mansfield that distinction is important. I don't need to repeat the submissions of those preceding me as to the importance of core participants playing an active role in this inquiry, but I would invite you, sir, to consider that these are individuals who have been feeling, or many of them have been feeling for a number of years, that their concerns about fire safety in Grenfell Tower were not considered, and who, on initial meetings after the crisis, came back again and again. I speak as a solicitor who met with those individuals at an early stage, and who came back again and again to everything that they had done to try and raise fire safety issues at Grenfell Tower, some of them over a period of years, and also to the efforts that they had made, in some cases on the night itself, to save those within their family. Mr. Chairman, you'll be minded very much of the importance that they are heard, but it is, I would say, a vital opportunity to empower those individuals by allowing them to feel part of the decision-making process. They already feel that they're going to be asked to give a great deal in this inquiry. Many of them feel exhausted by the day-to-day effort of surviving in hotel rooms and in the many processes of their grief. I would suggest that it would be perhaps a groundbreaking opportunity for members of a community who have not had an opportunity to influence public policy previously to do so, and that in turn would benefit the inquiry and wider society. Reference has been made already today to the Mcpherson-Lawrence inquiry and the importance of a diverse panel in ensuring the community's trust and confidence in that inquiry. My firm continues to be instructed by Doreen Lawrence, the mother of Stephen Lawrence, and the family remembers to this day, 20 years on from the inquiry, while they continue to fight in investigations concerning the police's conduct all those years ago. They do remember the inquiry as a crucial turning point in their campaign towards justice, and the key reason for that, Baroness Lawrence feels very strongly, is that the family not only had trust and confidence in the panel and in the inquiry throughout the process because of the appointment of a panel early on, but also that the outcomes of that inquiry were nuanced and properly contextualised because of the important input that having more people and a more diverse background was able to ensure. And so the only other matter on which I've been instructed to address you very briefly today is on the issue of early disclosure, about which many other individuals on this stand today have spoken already. This arises not just, I would say, from the needs and priorities of core participants who are now considering their own witness evidence, but also from a legitimate fear, if not a scepticism, that disclosure throughout this inquiry will be selective and perhaps incomplete, and that it will be a process to get to a point where members of the public feel that there has been full or approximately full disclosure. I say that with the greatest respect, sir, but what I mean is that, that we know from our experience of inquiries, and some of which my firm has been instructed in relation to, and others in the room today will be able to testify their experiences in relation to the Hillsborough inquiry and the defensiveness of institutions over a period of years where there was culpability attributed early on. My firm is instructed in the undercover policing inquiry, and it was reported over 1 year into that inquiry that files containing undercover police officers' intelligence had been destroyed. We've referred to that briefly in our submissions at paragraph 4. It's not to tap the present inquiry team on the knuckles and tell them to get their act together. I appreciate what's being done, but our feeling is that if a tranched approach to disclosure is made, so that things can get going, the process can get going early on, that will enable not only greater confidence in the inquiry, but also opportunity to identify early on gaps in disclosure. And I do endorse and reiterate the submission made by Mr Weatherby today, that we are at a loss to understand why we cannot have access to the letters that go out. Save that, I appreciate, in every request for disclosure, it would delay potentially the process to the hindrance of the inquiry were core participants to input at each disclosure request, given the volume of those requests. But I would suggest that for there to be a review process, at least routinely, for core participants and their solicitors, those affected, to review the wording of those letters, to input in them when it seems necessary, and to ask for clarification in terms of categories of documents that are being requested. I think that really would serve greatly to reassure our clients and their representatives. So I think that's all I had to address you on today.
All right. Well, thank you very much indeed. Next on my list, I have Mr. Johnson, appearing for core participants represented by Oliver Fisher. Yes,
My name is Lindsay Johnson, together with Jim Shepherd, we're instructed by Oliver Fisher in respect of a number of residents of the tower and the walkway, including disabled residents on the newly refurbished first floor of the tower, who will bring a further dimension, we believe, to the evidence in terms of the concerns over that refurbishment and its relationship to the fire. The advantage of speaking at the end of the day is that you've had the benefit of hearing the submissions made by others. Those comments that we've heard today build on the collaborative approach there has been between those who act for the core participants and who are survivors of the fire, and we hope to continue that cooperation as matters progress. We welcome the update from Council to the inquiry and the advances which he set out first thing this morning, which address a number of the concerns which we raised in our submissions that were raised more generally. We agree in broad terms with much of what has been said so far today by Council, but in particular we wish to associate ourselves with the comments of Mr Freedman in general and Mr Weatherby on the specific issue of disclosure. We also expressly agree with the points on experts made by Mr Thomas and the need for an expert on property maintenance. But for two short points which have been the subject of Mr Bates' submissions, there would be no need for us to trouble the inquiry with oral submissions at all. But we do so to emphasise two, we would say, related points. First, we agree with the submission of Russell Cook, which was alluded to by Mr Mansfield, that there is a need for an assessor with experience of social housing management, in particular tenant participation in housing management. That is essential as it brings a degree of expertise that is currently lacking. The difficulty perhaps here is that housing is something everyone believes themselves to know something about. We all have some involvement with it, but unfortunately we do not. And we are concerned that that is overlooked, and in our submission the evidence is essential and the assessor is essential to assist the understanding of the inquiry and to enable you to get to the answers you need to get to. The second issue relates to disclosure. Counsel to the inquiry asked for clarification as to why disclosure of the housing file is important. And Mr Freedman noted that the housing file will address who was in the property and will assist the tribunal inquiry in that regard. Of course, as Mr Bates pointed out, a housing file is much more than that. Counsel to the inquiry in opening pointed out in the context of expert reports for Phase 1, there is a need to understand the fire safety measures and how they performed. Well, the housing file will contain that information. It will provide any complaint made by tenants as to the issues of disrepair and the functioning of fire safety equipment and what steps were taken to address those concerns. And that's important not just in respect of the tower and the dwellings in the tower itself, but also in relation to the walkway, where there are some concerns and some issues raised in relation to gas safety issues, which it is said by some were ignored, and which you will want to consider when determining the cause of the fire. As noted by many, including Ms Munro today, there are those who believe that the cause of the fire was preventable. The housing file will demonstrate whether there were relevant concerns raised, by whom, and their relevance to the issues raised under Phase 1. And in that sense, such disclosure is tied to effective participation and openness. We'd therefore respectfully submit that disclosure of the individual housing files is essential, and I agree with Mr Bates that it is inconceivable that it would not be. They were the only two issues on which we wish to make submissions.
That's all you'd like to say at this stage? Well, thank you very much indeed. Now, I had some slightly late submissions from Mr Westgate, who is appearing for Mr Shahid Ahmed. Is Mr Westgate here? Mr Westgate, I'm sorry we had to put you in last, but you probably understand the reason.
Yes, sir. Yes, we do, and we are grateful to have the opportunity to speak. One of the advantages, I suppose, of going last is the more that people say, that the less you have to say at the end. And as Mr Johnson has just pointed out, that is an illustration of how effectively the cooperation between the core participants has operated, and something that we hope will continue. I only want to make 3 points, one about phasing, one about assessors, and one about expert evidence. So far as phasing is concerned, you've heard a great deal of submissions about the appropriateness of maintaining the phasing idea. We've said some things about that in our written submissions, and I don't propose to repeat those. I just want to make a point about the utility of continuing with the phasing idea. In particular, if phasing does continue, it raises a question about the status of findings in Phase 1, particularly if decisions that have been made in that phase, even on a provisional or basis, end up being made without full information that then end up being undermined in Phase 2. And that's a very real possibility, particularly as the process of more detailed consideration in Phase 2 may throw up all sorts of things that simply hadn't occurred during Phase 1. That, when the phasing proposal was first put forward, what was a necessary difficulty which would simply have to be worked around because of the urgency that then existed. Of course, that urgency hasn't gone away, and of course there is still a pressing need to reach early and recommendations about safety where necessary. But as the other parties have made clear, there are other ways of addressing that particular problem in the course of the inquiry. The virtue of moving away from phasing is that it does give the opportunity to get on with the thing which is the key concern, which is how could this have happened? And that also has a knock-on point about the involvement of some core participants, because there are some participants who may feel unable or unready to talk about the events of the fire itself, but who may have a great deal to say about the way in which the block was managed before then. And of course, if they have to wait until Phase 2, they have to wait. And those important concerns of theirs are delayed in their resolution and delayed in their having an opportunity to participate in the inquiry. That's all I want to say about phasing. The second point is about assessors, and here I can really follow on from what Mr Bates and Mr Johnson have just said about the importance of having assessor expertise with current practical housing management experience. It's the thrust of a recommendation which I understand is going to be made tomorrow by the FBU as well. And that's something which is of particular interest to those like Mr. Ahmed, for who I represent, who was the chairman of the Leaseholders Association, and who can speak to the relationship between him and the TMO and the authority about works and about addressing safety concerns. And it's important that you should have an assessor who is able to evaluate the response to those matters, and will also be able to inform what practical solutions or practical recommendations this inquiry can make in its report. And it also, importantly, goes to the point that was made earlier about the tenants having been systematically overlooked or ignored in the past. And again, an assessor will be able to bring a valuable viewpoint on that. So we support the point made that there should be assessor expertise directed particularly to housing management. And the third point deals with experts. The inquiry, of course, is instructing its own experts, and it's welcome to hear from the counsel to the inquiry this morning that they are sympathetic to the idea of call participants instructing in due course their own experts. Of course, that will be something which will have to be carefully handled and coordinated. But there is, of course, an intermediate stage, because it may well be that the call participants may want to put questions to the inquiry's experts, perhaps in writing, perhaps at a hearing. But in order to do that, they will need to have the assistance of expertise in order to understand the highly technical material that's been put before them, and to formulate appropriate questions. And the only point I make there, and it's not something where we can ask for a particular direction, but it's important that the call participants must be appropriately supported and resourced to be able to make sense of the reports and to comment on them. And as I say, we can't ask for a direction. All we can really ask for is to make the point in advance that we hope for a flexible and realistic approach when requests for assistance are made. Those are the only points I wish to make.
Well, thank you very much indeed. Yes, thank you. We've reached this point somewhat earlier than we had expected or thought we might. Before I take it any further, can I just check that there's no one else here representing survivors, bereaved or residents who was expecting to speak and hasn't been asked or invited to do so? Good. All right. Well, the question then is whether we call a halt for today. It's been a longish day. It's quite warm in here. And I suspect that Mr. Maxwell Scott, who's next on the list, would rather start in the morning. Is that?
I would prefer to start in the morning.
Yes.
So I'm entirely in your hands.
Yes. No, well, I think that we've got plenty of time in the diary tomorrow, unless anyone's going to stand up and tell me that the time they've been allotted isn't enough. No, well, in that case, I think the best thing is for me to rise now. Thank you all for your assistance, which has been considerable. Thank you all for being so concise, which is always welcome. And we shall sit again tomorrow at 10:30 and take it on from there. All right? Thank you very much indeed.